Concept of remedial law. Question: how shall the rules of court be construed? 1998 bar. A. The rules of court should be liberally constructed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. Sector 6, Rule 1. Question: what is the concept of remedial law? Distinguish between substantive law and remedial law. 2006 bar. A. Remedial law is a branch of public law which prescribes the procedural rules to be observed in litigations, whether civil, criminal, or administrative, and in special proceedings, as well as the remedies or reliefs available in each case. Substantive law is that part of the law which creates, defines, and regulates rights and obligations, the violation of which gives rise to a cause of action. On the other hand, remedial law prescribes the method of enforcing rights or obtaining redress for their invasion. Cf. Bustos v. Lucero, 81 Phil. 540, 650, 1948. Question: how are remedial laws implemented in our system of government? 2006 bar. A. Remedial laws are implemented in our system of government through the judicial system, including the prosecutorial service, our courts, and quasi-judicial agencies. Question: give brief answers to the following. 2017 bar. What is the doctrine of hierarchy of courts? A. The doctrine of hierarchy of courts provides that where there is a concurrence of jurisdiction by courts over an action or proceeding, there is an ordained sequence of recourse to such courts beginning from the lowest to the highest. A direct invocation of the Supreme Court's original jurisdiction should be allowed only when there are special and important reasons therefor. Montes v. Court of P1S, GR number 143797, May 4, 2006. What is the harmless error rule in relation to appeals? A. The harmless error rule in relation to appeals provides that the appellate court should not reverse a judgment as a result of any error or defect which does not affect the substantial rights of the parties. Sector 6, Rule 51, Bersamin, Appeal and Review in the Philippines 362. When does a public prosecutor conduct an inquest instead of a preliminary investigation? A. Under the rules of criminal procedure, the public prosecutor conducts an inquest instead of a preliminary investigation when a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation. Sector 6, Rule 112. Doctrine of non-interference or doctrine of judicial stability. Question: in rendering a decision, should a court take into consideration the possible effect of its verdict upon the political stability and economic welfare of the nation? 2003 bar. A. No, because a court is required to take into consideration only the legal issues and the evidence admitted in the case. The political stability and economic welfare of the nation are extraneous to the case. They can have persuasive influence, but they are not the main factors that should be considered in deciding a case. A decision should be based on the law, rules of procedure, justice, and equity. However, in exceptional cases, the court may consider the political stability and economic welfare of the nation when these are capable of being taken into judicial notice of and are relevant to the case. Jurisdiction. Supreme Court. Question: distinguish questions of law from questions of fact. 2004 bar. A. A question of law exists when the doubt or difference arises as to what the law is on a certain set of facts, while a question of fact is when the doubt or difference arises as to the truth or falsehood of the alleged facts. Ramos v. Pepsi-Cola Bottling Company of the Phil, GR No. L. 22533. February 9, 1967. Question: Goodfeather Corporation, through its president, Al Pacino, filed with the Regional Trial Court, RTC, a complaint for specific performance against Robert White. Instead of filing an answer to the complaint, Robert White filed a motion to dismiss the complaint on the ground of lack of the appropriate board resolution from the board of directors of Goodfeather Corporation to show the authority of Al Pacino to represent the corporation and file the complaint in its behalf. The RTC granted the motion to dismiss and, accordingly, it ordered the dismissal of the complaint. Al Pacino filed a motion for reconsideration which the RTC denied. As nothing more could be done by Al Pacino before the RTC, he filed an appeal before the Court of Appeals, CA. Robert White moved for dismissal of the appeal in the ground that the same involved purely a question of law and should have been filed with the Supreme Court, SC. However, Al Pacino claimed that the appeal involved mixed questions of fact and law because there must be a factual determination if, indeed, Al Pacino was duly authorized by Goodfeather Corporation to file the complaint. Whose position is correct? Explain. 2014 bar. A. Al Pacino is correct in claiming that the appeal involved mixed questions of fact and law. There is a question of law when the doubt or difference arises as to what the law is on a certain state of facts. On the other hand, there is a question of fact when the doubt or difference arises as to the truth or falsehood of the alleged facts. Marant Philippines Corporation v. Serio, GR number 197598, November 21, 2012. Since the complaint was dismissed due to the alleged lack of appropriate board resolution from the Board of Directors of Goodfeather Corporation, the appeal will necessarily involve a factual determination of the authority to file the complaint for the said corporation. Hence, the appeal before the Court of Appeals is correct. Court of Appeals. Question: give at least 3 instances where the Court of Appeals may act as a trial court. 2008 bar. In annulment of judgment under Secs. 5 and 6, Rule 47. Should the Court of Appeals find prima facie merit in the petition, the same shall be given due course and summons shall be served on the respondent, after which trial will follow, where the procedure in ordinary civil cases shall be observed. When a motion for new trial is granted by the Court of Appeals, the procedure in the new trial shall be the same as that granted by a regional trial court. Sector 4, Rule 53. A petition for habeas corpus shall be set for hearing. Sector 12, Rule 102. In a petition for the writs of amparo and habeas data, a hearing can be conducted. Under Section 12, Rule 124 of the Rules of Criminal Procedure, the Court of Appeals has the power to try cases and conduct hearings, receive evidence and perform any and all acts necessary to resolve factual issues cases which fall within its original and appellate jurisdiction. The Court of Appeals can grant a new trial based on the ground of newly discovered evidence. Sector 14, Rule 124. The Court of Appeals, under Section 6, Rule 46, whenever necessary to resolve factual issues, may conduct hearing thereon or delegate the reception of the evidence of such issues to any of its members or to an appropriate agency or office. Question: does the Court of Appeals have jurisdiction to review the decisions in criminal and administrative cases of the Ombudsman? 2006 bar. A. Yes, but only in administrative cases. In administrative and disciplinary cases, appeals from the Ombudsman must be taken to the Court of Appeals under Rule 43. Conversely, the Supreme Court has exclusive appellate jurisdiction over decisions of the Ombudsman in criminal cases. Lanting v. Ombudsman, GR number 141426, May 6, 2005. Fabian v. DeCierto, GR number 129742, September 16, 1998, Sector 14, M6770. Court of Tax Appeals. Filed with the Bureau of Internal Revenue a complaint for refund of taxes paid, but it was not acted upon. So, he filed a complaint with the Court of Tax Appeals raffled to one of its divisions. Mark's complaint was dismissed. Thus, he filed with the Court of Similar Appeals a petition for certiorari under Rule 65. Does the Court of Appeals have jurisdiction over Mark's petition? 2006 bar. A. No. The procedure is governed by Sector 11 of RA 9282, which provides that decisions of a division of the Court of Tax Appeals must be appealed to the Court of Tax Appeals en banc. Further, the CTA now has the same rank as the Court of Appeals and is no longer considered as a quasi-judicial agency. It is likewise provided in the said law that the decisions of the CTA Bank are cognizable by the Supreme Court under Rule 45 of the 1997 Rules of Civil Procedure. Sandiganquan. Question: the Ombudsman, after conducting the requisite preliminary investigation, found probable cause to charge Governor Matigas in conspiracy with Carpintero, a private individual, for violating Section 3(e) of Republic Act. R.A. Number 3019, Anti-Graft and Corrupt Practices Act as amended. Before the information could be filed with the Sandiganquan, Governor Matigas was killed in an ambush. This, notwithstanding, an information was filed against Governor Matigas and Carpintero. At the Sandiganquan, Carpintero, through counsel, filed a motion to quash the information on the ground of lack of jurisdiction of the Sandiganquan, arguing that with the death of Governor Matigas, there is no public officer charged in the information. Is the motion to quash legally tenable? 2014 Bar. A. No. While it is true that by reason of the death of Governor Matigas, there is no longer any public officer with whom he can be charged for violation of RA 3019, it does not mean, however, that the allegation of conspiracy between them can no longer be proved or that their alleged conspiracy is already expunged. The only thing extinguished by the death of Governor Matigas is his criminal liability. His death did not extinguish the crime, nor did it remove the basis of the charge of conspiracy between him and Carpintero. The requirement before a private person may be indicted for violation of Section 3(g) of RA 3019, among others, is that such private person must be alleged to have acted in conspiracy with a public officer. The law, however, does not require that such person must, in all instances, be indicted together with the public officer. Indeed, it is not necessary to join all alleged co-conspirators in an indictment for conspiracy. People v. Go. GR number 168539, March 25, 2014. Regional Trial Courts. Question: Santa filed against ERA in the RDC of Quezon City an action for specific performance, praying for the delivery of a parcel of land subject of their contract of sale. Unknown to the parties, the case was inadvertently raffled to an RTC designated as a special commercial court. Later, the RTC rendered judgment adverse to ERA, who, upon realizing that the trial court was not a regular RTC, approaches you and wants you to file a petition to have the judgment annulled for lack of jurisdiction. What advice would you give to ERA? Explain your answer. 2017 Bar. A. The advice I would give to ERA is that the petition for annulment of judgment on lack of jurisdiction will not prosper. It has been held that a special commercial court is still a court of general jurisdiction and can hear and try a non-commercial case. Concord Condominium Incorporated v. Baculio, GR 203678, February 17, 2016. Hence, the special commercial court has jurisdiction to try and decide the action for specific performance and to render a judgment therein. Question: Hades, an American citizen, through a dating website, got acquainted with Persephone, a Filipina. Hades came to the Philippines and proceeded to Baguio City where Persephone resides. Hades and Persephone contracted marriage, solemnized by the Metropolitan Trial Court Judge of Makati City. After the wedding, Hades flew back to California, United States of America, to wind up his business affairs. On his return to the Philippines, Hades discovered that Persephone had an illicit affair with fans. Immediately, Hades returned to the United States and was able to obtain a valid divorce decree from the Superior Court of the County of San Mateo, California, a court of competent jurisdiction against Persephone. Hades desires to marry Hestia, also a Filipina, whom he met at Bacchus Grill in Pasay City. 2015 Bar. As Hades' lawyer, What petition should you file in order that your client can avoid prosecution for bigamy if he desires to marry Hestia? A. As Hade's lawyer, I would file a petition for cancellation of entry of marriage under Rule 108 with prayer for recognition of foreign divorce judgment. In a case involving similar facts, the Supreme Court held that a foreign divorce decree must first be recognized before it can be given effect. The Supreme Court stated that the recognition may be prayed for in the petition for cancellation of the marriage entry under Rule 108. Corpus vs. Sto. Tomas, GR number 186571, August 11, 2010. In what court should you file the petition? A. I would file the petition in the Regional Trial Court of Makati City, where the corresponding civil registry is located. Sector 1, Rule 108. What is the essential requisite that you must comply with for the purpose of establishing jurisdictional facts before the court can hear the petition? A. For the Rule 108 petition, the jurisdictional facts are the following. Joinder of the local civil registrar and all persons who have or claim any interest which would be affected by petition. Notice of the order of hearing to the persons named in the petition. Publication of the order of hearing in a newspaper of general circulation in the province. Family courts. Question: How should the records of child and family cases in the family courts or RTC designated by the Supreme Court to handle family court cases be treated and dealt with? Under what conditions may the identity of parties in child and family cases be divulged? 2001 Bar. A. The records of child and family cases in the family courts or regional trial courts designated by the Supreme Court to handle family court cases shall be dealt with utmost confidentiality and shall not be divulged unless necessary and with authority of the judge. Sector 12, Family Courts Act of 1997. Question: Juliet, invoking the provisions of the Rule on Violence Against Women and Their Children, filed with the RTC designated as a family court a petition for issuance of a temporary protection order, TPO, against her husband, Romeo. The family court issued a 30-day TPO against Romeo. A day before the expiration of the TPO, Juliet filed a motion for extension. Romeo in his opposition raised, among others, the constitutionality of RA number 9262, the VWC law, arguing that the law authorizing the issuance of a TPO violates the Equal Protection and Due Process Clauses of the 1987 Constitution. The family court judge, in granting the motion for extension of the TPO, declined to rule on the constitutionality of RA number 9262. The family court judge reasoned that family courts are without jurisdiction to pass upon constitutional issues, being a special court of limited jurisdiction, and RA number 8369, the law creating the family courts, does not provide for such jurisdiction. Is the family court judge correct when he declined to resolve the constitutionality of RA number 9262? 2015 Bar. A. No. The family court judge is not correct when it declined to resolve the constitutionality of RA number 9262. In Garcia v. Dryland, the Supreme Court held that the family courts have authority and jurisdiction to resolve the constitutionality of a statute. In spite of its designation as a family court, the RTC remains to possess the authority as a court of general original jurisdiction to pass upon all kinds of cases, whether civil, criminal, special proceedings, land registration, guardianship, naturalization, admiralty, or insolvency. This authority is embraced in the general definition of judicial power to determine the valid and binding laws in conformity with the fundamental law. GR number 179267, June 25, 2013. Metropolitan Trial Courts / Municipal Trial Courts. Question: Estrella was the registered owner of a huge parcel of land located in a remote part of their barrio in Benguet. However, when she visited the property after she took a long vacation abroad, she was surprised to see that her childhood friend, John, had established a vacation house on her property. Both Estrella and John were residents of the same barangay. To recover possession, Estrella filed a complaint for ejectment with the Municipal Trial Court, MTC, alleging that she is the true owner of the land as evidenced by her certificate of title and tax declaration, which showed the assessed value of the property as P21,000.00. On the other hand, John refuted Estrella's claim of ownership and submitted in evidence a deed of absolute sale between him and Estrella. After the filing of John's answer, the MTC observed that the real issue was one of ownership and not of possession. Hence, the MTC dismissed the complaint for lack of jurisdiction. On appeal by Estrella to the Regional Trial Court, RTC, a full-blown trial was conducted as if the case was originally filed with it. The RTC reasoned that based on the assessed value of the property, it was the court of proper jurisdiction. Eventually, the RTC rendered a judgment declaring John as the owner of the land and, hence, entitled to the possession thereof. Was the MTC correct in dismissing the complaint for lack of jurisdiction? Why or why not? A. No. It is well settled that jurisdiction is determined by the allegations contained in the motion to dismiss has nothing to do in the determination of jurisdiction. Relative thereto, the MTC's has exclusive original jurisdiction over cases of forcible entry and unlawful detainer. Section 33, BP 129. Hence, the MTC is not correct in dismissing the complaint for lack of jurisdiction. At any rate, the rules allow provisional determination of ownership in ejectment cases when the defendant raises the defense of ownership in his pleadings and the question of possession cannot be resolved without deciding the issue of ownership. Sector 16, Rule 70. Accordingly, the inferior courts have jurisdiction to resolve questions of ownership whenever it is necessary to decide the question of possession in an ejectment case. Serrano v. Spouses Gutierrez, GR number 162366, November 10, 2006. Was the RTC correct in ruling that based on the assessed value of the property, the case was within its original jurisdiction and, hence, it may conduct a full-blown trial of the appealed case as if it was originally filed with it? Why or why not? 2014 Bar. A. No. It is settled that forcible entry and unlawful detainer cases are within the exclusive original jurisdiction of the MTC. Moreover, all cases decided by the MTC are generally appealable to the RTC irrespective of the amounts involved. Sector 22, BP 129. Quasi-judicial courts. Question: what court has jurisdiction over an action for specific performance filed by a subdivision homeowner against a subdivision developer? Explain. 2002 Bar. A. An action for specific performance by a subdivision homeowner against a subdivision developer is within the jurisdiction of the Housing and Land Use Regulatory Board, HLURB. Sector 1 of PD 1344 provides that the HLURB has jurisdiction over cases involving specific performance of contractual and statutory obligations filed by buyers of subdivision lots and condominium units against the owner, developer, dealer, broker, or salesman. Manila Bankers Life Insurance Corporation v. Eddie Incokwe, GR number 139791, December 12, 2003. Kakalala v. Farian, GR number 143233, October 18, 2004. Sector 1, PD 1344. Totality Rule. Question: lender extended to borrower a P100,000.00 loan covered by a promissory note. Later, borrower obtained another P100,000.00 loan again covered by a promissory note. Still later, borrower obtained a P300,000.00 loan secured by a real estate mortgage on his land valued at P500,000.00. Borrower defaulted on his payments when the loans matured. Despite demand to pay the P500,000.00 loan, borrower refused to pay. Lender, Applying the totality rule, filed against borrower with the Regional Trial Court, RTC, of Manila, a collection suit for P500, 0.00. Did lender correctly apply the totality rule and the rule on joinder of causes of action? 2015 bar. A. Yes. The lender correctly applied the totality rule and the rule on joinder of causes of action because where the claims in all the causes of action are principally for recovery of sum of money, the aggregate amount of the claim shall be the test of jurisdiction. Section 5, D Rule 2. Here, the total amount of the claim is P500, 000.00. Hence, the Regional Trial Court, RTC, of Manila has jurisdiction over the suit. At any rate, it is immaterial that one of the loans is secured by a real estate mortgage because the lender opted to file a collection of sum of money instead of foreclosure of the said mortgage. Note: RA number 11576 was enacted in 2021, increasing the jurisdiction of the RDCs in all actions and maritime jurisdiction where the demand or claims exceeds P2 million. Question at the trial, borrower's lawyer, while cross-examining lender, successfully elicited an admission from the latter that the 2 promissory notes have been paid. Thereafter, borrower's lawyer filed a motion to dismiss the case on the ground that as proven only P300, 000 was the amount due to lender, and which claim is within the exclusive original jurisdiction of the Metropolitan Trial Court. He further argued that lack of jurisdiction over the subject matter can be raised at any stage of the proceedings. Should the court dismiss the case? 2015 bar. A. No. The court should not dismiss the case. What determines the jurisdiction of the court is the nature of the action pleaded as appearing from the allegations in the complaint. The averments therein and the character of the relief sought are the ones to be consulted. Navida v. Hahn, Teodoro A. Dizon, Jr., GR number 125078, May 30, 2011. Accordingly, even if the defendant is able to prove in the course of the trial that a lesser amount is due, the court does not lose jurisdiction and a dismissal of the case is not in order. Padlin v. Stinglassen, GR No. 180321, March 20, 2013. Civil procedure. Personal actions and real actions. Question: what do you mean by A, real actions, and B, personal actions? 2006 bar. A. Real actions are actions affecting title to or possession of real property or an interest therein. All other actions are personal actions. Sector 1, Rule 4. Question: Eduardo, a resident of the city of Manila, filed before the Regional Trial Court, RTC, of Manila a complaint for the annulment of a deed of real estate mortgage he signed in favor of Galaxy Bank, Galaxy, and the consequent foreclosure and auction sale on his mortgaged Makati property. Galaxy filed a motion to dismiss on the ground of improper venue, alleging that the complaint should be filed with the RDC of Makati since the complaint involves the ownership and possession of Eduardo's lot. Resolve the motion with reasons. 2016 bar. A. The motion to dismiss should be granted. An action for nullification of the mortgage documents and foreclosure of the mortgaged property is a real action that affects the title to the property. Thus, venue of the real action is before the court having jurisdiction over the territory in which the property lies. Chua v. Total Office Products and Services, GR 152808, September 30, 2005. Being a real action, it shall be commenced and tried in the proper court which has jurisdiction over the area where the real property involved, or a portion thereof, is situated. Sector 1, Rule 4. Consequently, the complaint should be filed in the RDC of Makati where the mortgaged property is situated. Alternative answer. The motion to dismiss should be denied. An action for the annulment of a real estate mortgage is a personal action, which may be commenced and tried where the defendant or any of the defendants resides or may be found, or where the plaintiff or any of the plaintiffs resides or may be found. At the election of plaintiff, Section 2, Rule 4, Rules of Court, Chua versus Total Office Products and Services, September 30th, 2005, Orbita versus Orbita, GR number 166837, November 27th, 2006. Since the plaintiff resides in Manila, the complaint was properly filed in RDC of Manila. Question: distinguish cause of action from action. 1997, 1999 bar. A. An action is one by which a party sues another for the enforcement or protection of a right, or the prevention or redress of a wrong. Sector 3, A. Rule 2. A cause of action is the act or omission by which a party violates a right of another. Sector 2, Rule 2. Every action must be based on a cause of action. Sector 1, Rule 2. Question: A bought a Volvo sedan from ABC Cars for P5.0M. ABC Cars, before delivering to A, had the car rust-proofed and tinted by XYZ Detailing. When delivered to A, the car's upholstery was found to be damaged. ABC Cars and XYZ Detailing both deny any liability. Who can sue and on what causes of action? Explain. 2012 bar. A can file an action for specific performance and damages against ABC Cars since the damage to the Volvo sedan's upholstery was caused before delivery of the same to A, and therefore prior to the transfer of ownership to the latter. Article 1477, NCC. Under Article 1170 of the Civil Code, those who contravene the tenor of the obligation are liable for damages. Hence, an action for specific performance against ABC Corporation to deliver the agreed Volvo sedan in the contract-free form any damage or defects, with corresponding damages will lie against ABC Cars. Splitting a single cause of action and its effects. Question: what is the rule against splitting a cause of action and its effect on the respective rights of the parties for failure to comply with the same? 1999 bar. A. The rule against splitting a cause of action and its effect are that if two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment upon the merits in any one is available as a ground for the dismissal of the others. Sector 4, Rule 2. Question: A purchased a lot from B for P1,500,000.00. He gave a down payment of P500,000, signed a promissory note payable 30 days after date, and as a security for the settlement of the obligation, mortgaged the same lot to B. When the note fell due and A failed to pay, B commenced suit to recover from A the balance of P1,000,000. After securing a favorable judgment on his claim, B brought another action against A before the same court to foreclose the mortgage. A now files a motion to dismiss the second action on the ground of bar by prior judgment. Rule on the motion. 1999 bar. A. The motion to dismiss should be granted. When B commenced suit to collect on the promissory note, he waived his right to foreclose the mortgage. B split his cause of action. Under Sector 4, Rule 2, when a cause of action is split, the filing of one or a judgment upon the merits in any one is available as a ground for the dismissal of the others. Question: Raphael, a warehouseman, filed a complaint against V Corporation, X Corporation, and Y Corporation to compel them to interplead. He alleged therein that the three corporations claimed title and right of possession over the goods deposited in his warehouse, and that he was uncertain which of them was entitled to the goods. After due proceedings, judgment was rendered by the court declaring that X Corporation was entitled to the goods. The decision became final and executory. Raphael filed a complaint against X Corporation for the payment of P100,000.00 for storage charges and other advances for the goods. X Corporation filed a motion to dismiss the complaint on the ground of residential judicata. X Corporation alleged that Raphael should have incorporated in his complaint for interpleader his claim for storage fees and advances, that for his failure he was barred from interposing his claim. Raphael replied that he could not have claimed storage fees and other advances in his complaint for interpleader because he was not yet certain as to who was liable therefore. Resolve the motion with reasons. 2005 bar. A. The motion to dismiss should be granted. Raphael should have incorporated in his complaint for interpleader his claim for storage fees and advances, the amounts of which were obviously determinable at the time of the filing of the complaint. They are part of Raphael's cause of action which he may not split. Hence, when the warehouseman asks the court to ascertain who among the defendants are entitled to the goods, he also has the right to ask who should pay for the storage fees and other related expenses. The filing of the interpleader is available as a ground for dismissal for the second case. Sector 4, Rule 2. It is akin to a compulsory counterclaim which, if not set up, shall be barred. Sector 2, Rule 9. Ariza v. Diaz, GR number 133113, August 30, 2001. Question: Rolando filed a petition for declaration of the nullity of his marriage to Carmela because of alleged psychological incapacity of the latter. After trial, the court rendered judgment dismissing the petition on the ground that Rolando failed to prove the psychological incapacity of his wife. The judgment having become final, Rolando filed another petition, this time on the ground that his marriage to Carmela had been celebrated without a license. Is the second action barred by the judgment in the first? Why? 2002 bar. A. No. The second action is not barred by the judgment in the first because they have different causes of action. The first is for annulment of marriage on the ground of psychological incapacity under Article 36 of the Family Code, while the second is for the declaration of nullity of the marriage in view of the absence of a basic requirement, which is a marriage license, Arts. 9 and 35, 3 FC. They are different causes of action because the evidence required to prove them are not the same. Pagsizahan v. Se, GR No. L. 34885, January 28, 1980. Question: Elise obtained a loan of P3 million from Merchant Bank. Aside from executing a promissory note in favor of Merchant Bank, she executed a deed of real estate mortgage over her house and lot as security for her obligation. The loan fell due but remained unpaid. Hence, Merchant Bank filed an action against Elise to foreclose the real estate mortgage. A month after, and while the foreclosure suit was pending, Merchant Bank also filed an action to recover the principal sum of P3 million against Elise based on the same promissory note previously executed by the latter. In opposing the motion of Elise to dismiss the second action on the ground of splitting of a single cause of action, Merchant Bank argued that the ground relied upon by Elise was devoid of any legal basis considering that the two actions were based on separate contracts, namely, the contract of loan evidenced by the promissory note and the deed of real estate mortgage. Is there a splitting of a single cause of action? Explain your answer. 2017 bar. A. Yes, there is a splitting of a single cause of action. Under the Section 4, Rule 2, there is a splitting of a single cause of action if two or more suits are instituted on the basis of the same cause of action. Here, both suits, the foreclosure and the collection suit, arose from the same cause of action, that is, the non-payment by Elise of her P3 million loan from Merchant Bank. The fact that the two actions were based on separate contracts is irrelevant. What matters is that both actions arose from the same cause of action. Question: Mr. C sued Mr. D for reconveyance of property and damages, claiming that Mr. D, through fraud and forgery, was able to obtain the title to lot number 1234, which was previously registered in Mr. C's name. The complaint was filed before the regional trial court. Instead of filing an answer, Mr. D moved to dismiss the complaint on the ground of lack of cause of action. In opposition, Mr. C argued that lack of cause of action is not a ground for a motion to dismiss, as the ground provided under Section I, G, Rule 16 of the Rules of Court is failure to state a cause of action. Distinguish the concepts of lack of cause of action and failure to state a cause of action. Based on this distinction, Is Mr. C's opposition tenable? Explain. 2019 bar. A. The two grounds are distinguished as follows. Failure to state a cause of action refers to the insufficiency of the allegations in the pleading, while lack of cause of action is the insufficiency of the factual basis for the action. Dismissal for failure to state a cause of action may be raised as affirmative defense in the defendant's answer, while dismissal for lack of cause of action may be raised at any time after the questions of fact have been resolved on the basis of stipulations, admissions, or evidence presented by the plaintiff through a demurrer to evidence under Rule 33. Based on the above distinctions, Mr. C's opposition was tenable. Joinder and misjoinder of causes of action. Question: what is the rule on joinder of causes of action? 1999 bar. A. The rule on joinder of causes of action is that a party may in one pleading assert, in the alternative or otherwise, as many causes of action as he may have against an opposing party, provided that the rule on joinder of parties is complied with. The joinder shall not include special civil actions or actions governed by special rules, but may include causes of action pertaining to different venues or jurisdictions provided one cause of action falls within the jurisdiction of a regional trial court and venue lies therein, and the aggregate amount claimed shall be the test of jurisdiction where the claims in all the causes of action are principally for the recovery of money. Sector 5, Rule 2. Question: give the effects of the following. Splitting a single cause of action, and A. The effect of splitting a single cause of action is found in the rule as follows. If two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment on the merits in any one is available as a ground for the dismissal of the others. Sector 4, Rule 2. Non-joinder of a necessary party. 1998 bar. A. The effect of the non-joinder of a necessary party may be stated as follows. The court may order the inclusion of an omitted necessary party if jurisdiction over his person may be obtained. The failure to comply with the order for his inclusion without justifiable cause is a waiver of the claim against such party. The court may proceed with the action, but the judgment rendered shall be without prejudice to the rights of such necessary party. Sector 9, Rule 3. Question: A secured two loans from B. One for P500,000.00 and the other for payable on different dates. Both have fallen due. Is B obliged to file only one complaint against A for the recovery of both loans? Explain. 1999 bar. A. No. Joinder is only permissive since the loans are separate loans which may be governed by the different terms and conditions. The two loans give rise to two separate causes of action and may be the basis of two separate complaints. Question: Perry is a resident of Manila, while Ricky and Marvin are residents of Batangas City. They are the co-owners of a parcel of residential land located in Pasay City with an assessed value of PAO,000.00. Perry borrowed PAO,000.00 from Ricky, which promised to pay on or before December 1, 2004. However, Perry failed to pay his loan. Perry also rejected Ricky and Marvin's proposal to partition the property. Ricky filed a complaint against Perry and Marvin in the RDC of Pasay City for the partition of the property. He also incorporated in his complaint his action against Perry for the collection of the latter's P100,000.00 loan, plus interests and attorney's fees. State with reasons whether it was proper for Ricky to join his causes of action in his complaint for partition against Perry and Marvin in the RDC of Pasay City. 2005 bar. A. It was not proper for Ricky to join his causes of action against Perry in his complaint for partition against Perry and Marvin. The causes of action may be between the same parties, Ricky and Perry, with respect to the loan, but not with respect to the partition, which includes Marvin. Moreover, the supposed joinder includes a special civil action, thus, not allowed under Sector 5, B Rule 2. Parties to a civil action. Real parties in interest, indispensable parties, representatives as parties, necessary parties, indigent parties, alternative defendants. Question: in 1996, Congress passed Republic Act No. 8189, otherwise known as the Voters Registration Act of 1996, providing for the computerization of elections. Pursuant thereto, the COMELEC approved the Voters Registration and Identification System (VRIS) project. It issued invitations to pre-qualify and bid for the project. After the public bidding, Photokina was declared the winning bidder with a bid of P6 billion and was issued a notice of award. But COMELEC Chairman Jenner Go objected to the award on the ground that under the Appropriations Act, the budget for the COMELEC's modernization is only Pi billion. He announced to the public that the VRS project has been set aside. 2 commissioners sided with Chairman Go, but the majority voted to uphold the contract. Meanwhile, Photokina filed with the RTC a petition for mandamus to compel the COMELEC to implement the contract. The Office of the Solicitor General, OSG, representing Chairman Go, opposed the petition on the ground that mandamus does not lie to enforce contractual obligations. During the proceedings, the majority commissioners filed a manifestation that Chairman Go was not authorized by the COMELEC and Bank to oppose the petition. May the OSG represent Chairman Go before the RTC notwithstanding that his position is contrary to that of the majority? 2002 bar. A. Yes, the OSG may represent the COMELEC chairman before the RTC notwithstanding that his position is contrary to that of the majority of the commission members in the COMELEC. Being an independent office, the hands of the OSG are not shackled to the cause of its client agency. In the discharge of its task, the primordial concern of the OSG is to see to it that the best interest of the government is upheld. This is regardless of the fact that what it perceived as the best interest of the government runs counter to its client agency's position. COMELEC v. Quijano, Padi 11A, G. R. Number 151992, September 18, 2002. Question: half-brothers Roscoe and Salvio inherited from their father a vast tract of unregistered land. Roscoe succeeded in gaining possession of the parcel of land in its entirety and transferring the tax declaration thereon in his name. Roscoe sold the northern half to Bono, Salvio's cousin. Upon learning of the sale, Salvio asked Roscoe to convey the southern half to him. Roscoe refused, as he even sold 1/3 of the southern half along the west to Carlo. Thereupon, Salvio filed an action for the reconveyance of the southern half against Roscoe only. Carlo was not imblooded. After filing his answer, Roscoe sold the middle third of the southern half to Nina. Salvio did not amend the complaint to implead Nina. After trial, the court rendered judgment ordering Roscoe to reconvey the entire southern half to Salvio. The judgment became final and executory. A writ of execution having been issued, the sheriff required Roscoe, Carlo, and Nina to vacate the southern half and yield possession thereof to Salvio as the prevailing party. Carlo and Nina refused, contending that they are not bound by the judgment as they are not parties to the case. Is the contention tenable? Explain fully. 2008 bar. A. Yes. In case of transfer of interest pending litigation, the action may be continued by or against the original party unless the court, upon motion, directs a person to be substituted in the action or joined with the original party. Sector 19. Rule 3. The owners of property over which reconveyance is asserted are indispensable parties and must be joined in the action. Accordingly, the contention of Carlo, who is such party to the action filed by Salvio, is tenable. He is not bound by the judgment because he became a co-owner of the land before the case was filed, and yet he has not been included as a party thereto. Machagina Integrated Wood Products Incorporated v. Court of Appeals. GR number 98310, October 24, 1996. Ma. Valencia Santana Cruz v. Court of Appeals, GR number 120176, July 20, 2001. Nina, however, is a successor in interest of Roscoe and privy to the case. Hence, she is bound by the judgment as against Roscoe, although she is not party to the case. Sector 19, Rule 3, Cabrizos v. Taro, GR No. L. 46843, October 18, 1988. A judgment is conclusive between the parties and their successors in interest by title subsequent to the case. Sector 47, Rule 39. Question: Strauss filed a complaint against Wagner for cancellation of title. Wagner moved to dismiss the complaint because Grieg, to whom he mortgaged the property as duly annotated in the TCT, was not impleaded as defendant. Should the complaint be dismissed? A. No. The complaint should not be dismissed because the mere non-joinder of an indispensable party is not a ground for the dismissal of the action. Sector 11, Rule 3, Republic v. Hahn, Mangoterra, GR number 170375, July 7, 2010. If the case should proceed to trial without Grieg being impleaded as a party to the case, what is his remedy to protect his interest? 2015 Bar. A. If the case should proceed to trial without Grieg being impleaded as a party, he may intervene in the action. Sector 1, Rule 19. He may also file a petition for annulment of judgment under Rule 4, should a judgment be already rendered. In Metrobank v. Hahn, Floro Alejo, GR number 141970, September 10, 2001, the Supreme Court held that in a suit to nullify an existing Torrens Certificate of Title, TCT, in which a real estate mortgage is annotated, the mortgagee is an indispensable party. In such suit, a decision canceling the TCT and the mortgage annotation is subject to a petition for annulment of judgment, because the non-joinder of a mortgagee deprived the court of jurisdiction to pass upon the controversy. Question: Spouses Marlon and Edith have three children ages 15, 12, and 7, who are studying at public schools. They have a combined gross monthly income of P30,000, and they stay in an apartment in Manila with a monthly rent of P5,000. The monthly minimum wage per employee in Metro Manila does not exceed P13,000.00. They do not own any real property. The spouses want to collect a loan of P25,000 from Jojo, but do not have the money to pay the filing fees. Would the spouses qualify as indigent litigants under Section 19, Rule 141 on legal fees? 2016 Bar. A. No, the spouses would not qualify as indigent litigants under Section 19, Rule 141 since their combined gross monthly income of P30,000.00 exceeds P26,000, the amount double the monthly minimum wage. If the spouses do not qualify under Rule 141, what other remedy can they avail of under the rules to exempt them from paying the filing fees? 2016 Bar. A. The other remedy the spouses can avail of under the rules to exempt them from paying the filing fees is to apply for exemption pursuant to the indigency test under Section 21, Rule 3 of the Rules of Court if they can prove that they have no money or property sufficient and available for food, shelter, and basic necessities for themselves and their family. SPS, Algura v. City of Naga, October 30, 2006. Misjoinder and non-joinder of parties. Question: Hannah, a resident of Manila, filed a complaint for the partition of a large tract of land located in Oriental Mindoro. She impleaded her two brothers John and Adrian as defendants, but did not implead Laika and Agatha, her two sisters who were permanent residents of Australia. Arguing that there could be no final determination of the case without impleading all indispensable parties, John and Adrian moved to dismiss the complaint. Does the trial court have a reason to deny the motion? Explain your answer. 2017 Bar. A. Yes. The trial court has reason to deny the motion. Section 11, Rule 3 Rules of Court states that neither misjoinder nor non-joinder of parties is a ground for the dismissal of an action. The petitioner can still amend his initiatory pleading in order to implead Laika and Agatha, for under the same rule. Such amendment to implead an indispensable party may be made on motion of any party or on the trial court's own initiative at any stage of the action and on such terms as are just. Ableza v. Republic, GR number 158298, August 11, 2010. Question: Ms. A filed a complaint for damages against Ms. B, alleging that Ms. B negligently caused the demolition of her house's concrete fence, the top half of which fell on the front portion of Ms. A's car and permanently damaged its engine. In her answer, Ms. B denied any personal liability for the damage caused to Ms. A's car, averring that she merely acquiesced to the advice of her contractor, XYZ Construction Company, to have the concrete fence demolished. Thus, damages, if any, should be collected from it. Thereafter, Ms. A filed a motion for judgment on the pleadings, alleging that Ms. B's statement in her answer is actually a negative pregnant. Ms. B opposed the motion, reiterating her defense in her answer, which purportedly rendered judgment on the pleadings improper. Ms. B also moved for the dismissal of the case on the ground of non-joinder of XYZ Construction Company, which she alleged is an indispensable party to the case. Assuming that XYZ Construction Company is an indispensable party, is its non-joinder a ground for the dismissal of the case? Explain. 2019 Bar. A. No. The non-joinder of XYZ Construction Company as an indispensable party is not a ground for the dismissal of the case. The remedy is to implead the party claimed to be indispensable, considering that the parties may be added by order of the court, on motion of the party or on its own initiative at any stage of the action. In Plasabas v. Se, GR number 166519, March 31, 2009, it was held that the non-joinder of indispensable parties is not a ground for the dismissal of an action. 1I. Question: distinguish a derivative suit from a class suit. 2005 Bar. A. A derivative suit is a suit in equity that is filed by a minority shareholder in behalf of a corporation to redress wrongs committed against it, for which the directors refuse to sue, the real party in interest being the corporation itself. Lim v. Limu, GR number 138343, February 19, 2001. A class suit is filed in behalf of many persons so numerous that it is impracticable to join all as parties. Sector 12, Rule 3. Effective death of party litigant. Question: what is the effect of the death of a party upon a pending action? 1999 Bar. A. When the claim in a pending action is purely personal, the death of either of the parties extinguishes the claim and the action is dismissed. When the claim is not purely personal and is not thereby extinguished, the party should be substituted by his heirs or his executor or administrator. Sector 16, Rule 3. If the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment in the court in which the action was pending at the time of such death, it shall not be dismissed, but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced in the manner provided in the rules for prosecuting claims against the estate of a deceased person. Section 20, Rule 3. Question: PJ engaged the services of attorney ST to represent him in a civil case filed by OP against him, which was docketed as civil case number 123. A retainership agreement was executed between PJ and attorney ST whereby PJ promised to pay attorney ST a retainer sum of P24,000.00 a year and to transfer the ownership of a parcel of land to attorney ST after presentation of PJ's evidence. PJ did not comply with his undertaking. Attorney ST filed a case against PJ which was docketed as civil case number 456. During the trial of civil case number 456, PJ died. Is the death of PJ a valid ground to dismiss the money claim of attorney ST in civil case number 456? Explain. A. No. Under Sector 20, Rule 3, when the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment in the court in which the action is pending at the time of such death, it shall not be dismissed, but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced in the manner especially provided in the rules for prosecuting claims against the estate of the deceased person. Will your answer be the same with respect to the real property being claimed by attorney St. in civil case number 456? Explain. 1999, 2000, 2009 bar. A. Yes. An action to recover real property in any event survives the death of the defendant. Sector 1, Rule 87. However, a favorable judgment may be enforced in accordance with Sector 7, B, Rule 39 against the executor or administrator or successor in interest of the deceased in accordance with Sector 7, B, Rule 39. Question A filed a complaint for the recovery of ownership of land against B, who was represented by her counsel X. In the course of the trial, B dies. However, X failed to notify the court of B's death. The court proceeded to hear the case and rendered judgment against B. After the judgment became final, a writ of execution was issued against C, who, being B's sole heir, acquired the property. If you were the counsel of C, what course of action would you take? 1998 bar. A. As counsel of C, I would move to set aside the writ of execution and the judgment for lack of jurisdiction and lack of due process in the same court because the judgment is void. If X had notified the court of B's death, the court would have ordered the substitution of the deceased by C, the sole heir of B, Sector 16, Rule 3. The court acquired no jurisdiction over C, upon whom trial and the judgment are not binding. Ferreira v. Ibarra v. De Gonzalez, Gr. No. L. 11567, July 17, 1958, BDA. De La Cruz v. Court of Appeals, Gr. No. L. 41107, February 28, 1979, Lawas v. Court of a P1S, Gr. No. L. 45809, December 12, 1986. I could also file an action to annul the judgment for lack of jurisdiction because C, as the successor of B, was deprived of due process and should have been heard before judgment. Rule 47. Question: Prince Chong entered into a lease contract with King Kong over a commercial building where the former conducted his hardware business. The lease contract stipulated, among others, a monthly rental of P50, 0.00 for a 4-year period commencing on January 1, 2010. On January 1, 2013, Prince Chong died. Kinail Chong was appointed administrator of the estate of Prince Chong, but the former failed to pay the rentals for the months of January to June 2013 despite King Kong's written demands. Thus, on July 1, 2013, King Kong filed with the Regional Trial Court, RTC, an action for rescission of contract with damages and payment of accrued rentals as of June 30, 2013. Can Kinail Chong move to dismiss the complaint on the ground that the RTC is without jurisdiction since the amount claimed is only P300, 0.00? A. No. Kinail Chong cannot move to dismiss the complaint. An action for rescission of contract with damages and payment of accrued rentals is therefore cognizable by the Regional Trial Court. Seferina de Ungria v. Court of Appeals, GR number 165777, 25, 2011. If the rentals accrued during the lifetime of Prince Chong, and King Kong also filed the complaint for sum of money during that time, will the action be dismissible upon Prince Chong's death during the pendency of the case? 2014 bar. A. No. The action will not be dismissible upon Prince Chong's death during the pendency of the case. When the action is for recovery of money arising from contract, and defendant dies before entry of final judgment in the court in which the action was pending at the time of such death, it shall not be dismissed, but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced under Rule 86, Sector 20, Rule 3. Relative thereto, since the complaint for sum of money filed by King Kong survives the death of Prince Chom, the case shall not be dismissed and the court shall merely order the substitution of the deceased defendant. Sarsaba v. VDA. Date, GR number 175910, July 30, 2009. Question: Chica sued Gringo, a Venezuelan, for a sum of money. The Metropolitan Trial Court of Manila, METC, rendered a decision ordering Gringo to pay Chica P50,000 plus legal interest. During its pendency of the appeal before the RTC, Gringo died of acute hemorrhagic pancreatitis. Attorney Perfecto, counsel of Gringo, filed a manifestation attaching the death certificate of Gringo and informing the RTC that he cannot substitute the heirs since Gringo did not disclose any information on his family. As counsel for Chica, what remedy can you recommend to your client so the case can move forward and she can eventually recover her money? Explain. 2016 Bar. A. The remedy I can recommend to my client Chica is to file a petition for settlement of the estate of Gringo and for the appointment of an administrator. Chica, as a creditor, is an interested person who can file the petition for settlement of Gringo's estate. Once the administrator is appointed, I will move that the administrator be substituted as the defendant. I will also file my claim against Gringo as a contingent claim in the probate proceedings pursuant to Rule 86 of the Rules of Court.